It's now 7:30. We have 5 items on the agenda. The first one is the approval of minutes. The second one is wireless, AT&T wireless. The third one is Teresa Hoy. The fourth one is A+ waste and recycling. And the fifth one is the Star Mill. Okay, we'll go with number 1, which are the minutes of the last meeting. Anybody have any corrections, errors, omissions, or anything else on the minutes of the last meeting? If not, is there a motion to approve them?
So moved.
Second.
Motion made and seconded. All in favor?
Aye.
Opposed? So voted unanimously. Second one is AT&T Wireless. To hear the petition of Timothy Green on behalf of AT&T relative to his request to allow for the replacement of 2 panel antennas to the existing communications tower located at 121 Pine Street, Middleborough, Assessors Map 095-6224. Declare the hearing open. Floor is yours.
Thank you. As mentioned, my name is Tim Green. I'm here on behalf of AT&T Wireless. AT&T currently has an existing facility at 121 Pine Street. They currently have 9 antennas at 147 feet on the lattice tower. The antennas point in 3 different directions, please 30 degrees, 150 degrees, and 270 degrees, so in order to cover 360 degrees. The antennas that are pointing at 270 degrees are not performing the way AT&T would like. They'd like to change out 2 of the antennas with 2 other antennas. Add a couple remote radio heads with it in order to upgrade the system. They're having some complaints about network problems on that sector with various issues, either not carrying calls or not being able to complete calls. In order to change out the antennas to provide a network upgrade. There's currently 9 antennas. There will continue to be 9 antennas. Any changes currently need to go through your board. So looking to get approval to do that, upgrade the antennas, and go on our merry way.
Any questions from the board?
Question, please.
Yes, Mr.
You're not
Gray.
going to do any groundwork, change the footprint of the fence or layout or any additional buildings within the
No.
fenced-in area? The only work will be on the tower?
Work will be on the tower. We'll do some work inside our existing building.
Oh, yeah.
Change out some equipment, but we're not adding any equipment. We're not changing the fenced area at the bottom.
Thank you.
Any other questions? Any questions from any member of the audience? If not, what is the pleasure of the board?
Mr. Chairman,
Yes,
if you don't mind, can I read in a letter from our building?
you certainly can, sir.
The subject is 121 Pine Street, map 095, lot 6224, dated September 4th, 2013. Honorable Board, I've reviewed the petition submitted by Timothy Green of AT&T with plans dated July 23rd, 2013, relative to his request to be allowed for a modification on the existing communications tower. The antenna is located at 121 Pine Street, although the attached plans have an address of 137 Pine Street. I would support this request subject to an analysis for the capacity of the existing structures to support the proposed equipment is conducted prior to construction. Respectfully submitted, Robert Taylor.
Not a problem. You're going to get a hold of him?
There will be a structural analysis submitted with the building permit application.
Okay.
I believe there already was one, but that's fine. Well, we can comply.
You'll make sure, anyway?
Yes.
Okay, that's all we need. Any other questions from the board? Any other questions from the audience? If not, what is the pleasure of the board? Somebody have a motion?
Mr. Chairman, I'd like to make a motion that we approve the petition for new singular wireless PCS for the, hang on 1 second. Relative to his request to allow for the replacement of 2 panel antennas to the existing communications tower located at 121 Pine Street, Middleborough, Assessors Map 095, Lot 6224, with the only stipulation that, as per the building commissioner's letter, he will have a structural analysis done for capacity of the new antennas going up, and that will be submitted to the building inspector prior to any work being done based on his approval, and subject to the plan that was received and dated, let's see, it's dated August 15th, 2013.
Second motion.
Motion made and seconded. Any other discussion by the board? If not, Mr. Priestley?
I'm in favor.
Dr. Braun?
In favor.
Mrs. Pulsifer?
In favor.
Mr. Diegeli?
In favor?
And myself in favor. Those 5-0 in favor. You will receive formal notification anyway.
Thank you.
Okay? Thank you. The next one is to hear the petition of Teresa Hoy, 182 Cherry Street, regarding an accessory apartment. If you just stand up to the microphone, that's all. Go ahead, tell us what you want to do.
Hi, my name is Teresa Hoy. I live at 182 Cherry Street in Middleborough, and I would like to put an accessory apartment attached to our home for our parents to move in, which is Donald and Jeanette Valancourt, right here.
Questions from the board?
We have a letter from the...
Yep, we have a letter, Mr. Chairman, if you'd like
Go
to
ahead.
read it from our building commissioner. It's dated September 9th, 2013, and the subject is the accessory apartment located at 182 Cherry Street, map 071, lot 3027. Owners are Joseph W. and Teresa M. Hoy. Dear Honorable Board, I have reviewed the petition submitted by Teresa Hoy for her request for a special permit to construct an accessory apartment to the left side of the existing single-family dwelling located at 182 Cherry Street. The applicant does meet the zoning requirements for an accessory apartment. I offer the following. 1, the plot plan layout shows the location of the proposed addition. 2, the accessory apartment would be for Donald and Jeanette Valancourt? Valancourt, thank you. 3, the new addition does meet a less than 50% floor area required. 4, the accessory apartment will have the required 2 means of egress. I would support this request. Please call if you have any questions in this regard. Respectfully submitted, Robert J. Whaley.
Any member of the board have any other questions?
Chairman,
Yes?
are you on town sewer?
No.
No?
Have your septic system been checked and approved by the health commissioner?
Yes.
Thank you.
Anybody else have any other questions?
Mr. Chairman, I don't have a question, but I would make a comment. In the past, when we've approved this type of petition, we limit it to specific individuals, the ones that you've listed on this. And it's with the understanding that in the event that those 2 individuals would no longer live there, this would revert back to a single-family house.
Correct.
Do you understand that?
Yes.
Okay. Thank you.
Any other questions from the board? Any questions or comments from anybody in the audience regarding this petition? If not, what is the pleasure of the board? Would somebody like to make a motion?
Mr. Chairman, I'd like to move that the petition of Teresa Hoy, 182 Cherry Street, Middleborough, Mass. 02346, relative to her request to allow for an addition for an accessory apartment for her parents located at 182 Cherry Street, Middleborough, Assessors Map 071, Lot 3027, be approved with the following stipulations. First, that it be built in accordance with the design and plans that were submitted this evening. And second, that the occupants of the accessory apartment are the 2 individuals, Donald and Jeanette Valancourt. And in the event that either of them is, or both of them are no longer living in the home, before it could be occupied by anyone else, the Hoys would have to come back to this board for approval.
Anybody else have anything they want to?
Could we please say that as per the plans dated tonight, because I see no date on these plans.
Tammy, will you put a date on it, please, and we'll just use that as our date, please.
Second the motion.
Motion is made and seconded, subject to the stipulation. Any member of the board have any other questions? Anybody in the audience have any questions or comments? If not, what is the pleasure of the board? Did you make the motion? Yeah, with the stipulation? Yep. Okay. Sorry, I was reading this. My fault. Okay. Dr. Braun?
In favor?
Mrs. Pulsifer?
In favor.
Mr. Diegoli?
In favor.
Mr. Freitas? In favor. And myself in favor, though it's 5-0 in favor. You will receive notification from this board of the vote tonight, of which you will have to take it to the Plymouth County Registry of Deeds, have it registered, and when you, any questions on what to do beyond that, Tammy, just call her, and she'll be glad to walk you through it.
Thank you very much.
Just a matter of
Good luck.
time. Okay?
Thank you. Thank you very much.
You're welcome. The next one is a continuation of a hearing started,
A year ago.
right, on September 13th, 2012, to hear the petition of John Wyman Esquire for A-plus Waste and Recycling Services relative to his request to allow for a special permit per Section 4E2 of the zoning bylaws to establish a single-stream recycling operation and composting operation of leaf and yard waste and related material, and a variance per Section 5E3 side setback relative to a firm location of the existing building. Subject property is 88 River Street, Middleborough, Assessors Map 002, Lot 5463. Declare the hearing open, and as I said, it's a continuation of about a year ago. Floor is yours.
Thank you, Mr. Chairman. Again, my name is John Wyman. I'm here on behalf of the applicant, A-plus Waste and Recycling Services. We were here last on August 22nd, at which point the board had received a comment letter from your peer reviewer, and had also received a response from our engineer to the concerns, or at least questions that were raised by your peer reviewer. Those comments were given to the peer reviewer, but you had not received information from the peer review outfit as to what was addressed by our engineer. I believe the board has received that as from your peer review, and has basically signed off on the environmental impact statement that was prepared by ESS on behalf of the applicant. So that was one thing that you did not have in your packet, and was cause to continue further the hearing. I believe as well, I was asked to meet with Tammy to go over the submissions that we've made over the last year. As Mr. Diegoli so aptly pointed out, this has been going on for some time, and there's been some submissions back and forth. We did arrange those submissions. I met with her, and I believe we've accomplished that as well. And there were some issues raised by a planning board letter that came in the night of the hearing. I asked SciTech to comment on that, and there was a letter dated September 4th from SciTech addressing in narrative form what was actually shown on the site plans, the site drainage and roof drainage and so forth, that the planning board was asking what we were doing with surface drainage, and it was shown on the plan, but in narrative form, explaining what the site plan actually does. Those were the three issues that were outstanding, Mr. Chairman. I think we've submitted the materials necessary to bring perhaps this thing to a close. If I'm mistaken,
Go ahead.
I will be happy to address that.
I would like to agree with you that it would come to a conclusion, but I don't think it has. I think there are things going on from what I have read back and forth down there that should not be happening and are happening.
And what is that, Mr. Chairman?
Things being brought in, as I understand it, it was limited to certain items, and it's been moving, other items have been moved around,
No, that
and it's
has,
not supposed to be.
no, nothing has been, we had a
You
gentleman's
haven't had
agreement.
any trucks in there in the last
We
2
have,
months?
we have had a gentleman's agreement not to accept any more material, and that's been the case. No material has been brought in.
That's not what I understand.
From whom did you understand
I
it?
can't tell you at this point, because I don't have it. I'm assuming that it came from the health officer, but I'm not 100% sure of that. I read so many things today on this that I can't answer it.
The health officer,
But
the health
petitioner
agent
probably
hasn't been on the property since April.
Excuse me, go ahead.
The health agent hasn't been on the property since April.
I can't answer for her.
Is she here tonight, or is
No.
she?
No, she's not here tonight.
So you are repeating issues that she has raised? How can I address those?
I'm not saying you can. What I'm saying is I understand it, and the board can correct me if I'm wrong, that there's nothing to be brought in or taken out.
I think the gentleman's agreement was that the stockpile material that has been cured, up to 6,000 yards, was able to be removed.
Is there material coming in?
No.
No.
None?
My
No.
name is Ron High, I'm the owner of the property. I agreed to this board that I would not bring in any material, and I have not brought in one piece of material, as I made that gentleman's agreement. Not one piece of
We
material.
agreed that we would be able to take the cured stuff off.
Cured stuff off, but not,
That's right.
but
So
not,
that would facilitate trucks coming in and out.
right, but not bringing new
No
stuff
new
in.
material has come into that property since we made that agreement, sir.
Okay.
I don't think the health officer's memo mentioned material coming in.
Just mentions material being moved, I believe.
Well, we had an agreement that they could move stuff
Yep.
off, so we can't
Yep.
hold that against them.
Nope, I'm not holding anything against them. We have not had a motion or
Mr. Chair?
anything prepared from the health department. We have a memo from her dated September 11th. I don't know if you have a copy of that or not.
I do.
Okay, as long as you do, that's the important thing.
Maybe we should read that in the record.
And other than that, we received the reports back, and she is working on them at the present time to come up with a motion of some kind that will be all-encompassing so that we know exactly which way we stand.
I thought that's what the board was doing.
Well, she's
She's
working
not.
on it as the health department.
Issues.
But the conditions that the board is going to impose, aren't those the board's conditions?
They will be the board's conditions. She's just the author of the motion. And the board will either approve the motion or make corrections and additions or
She writes your
eliminations.
decisions.
We do not have anybody to write it. She's the closest individual that could write it.
Mr. Chairman, I honestly have a problem with that.
Well,
I don't think she should be writing a damn thing that we put in, period.
who would you propose do it?
I don't see why, I'm looking at this that he presented,
Yep.
and my God, I'm stunned at how long it is right now, and I haven't had much time to read it. But if I were going to make that decision, it would be about 3 sentences long, period. And as far as I'm concerned, any information from the Board of Health really goes against 9.25 of our zoning bylaw. It's considered submittal to other boards. It says the zoning board of appeals shall submit applications for special permits to the Board of Health, Planning Board, Conservation Commission, Historic Commission, Building Inspector, Department of Public Works, and other such boards or agencies, and shall make recommendations as they deem appropriate. Copies of such recommendations shall be sent to the Zoning Board of Appeals and to the applicant, provided, however, that failure of any such board or agency to make recommendations within 21 days of receipt by such board or agency of the petition shall be deemed lack of opposition thereto. And as far as I'm concerned, this letter that she has just written is almost a full year old. It should have been answered, it should have been written, if that was her concern, a long time ago. And the other thing is, if she's that concerned about it, why the hell isn't she here? I have a real problem with that. Thank you.
Okay, if you don't want her to assist in writing the complete motion.
She hasn't
on the
even...
back, Joe, wait a minute. Or the backup to the motion, would you like to do it? I'm not going to do it, because it's too complicated for me.
If I were to make a motion, it would be brief, believe me.
You can't do it brief.
There is no reason we can't do it brief. This is an industrial district bylaw request. It doesn't have to be complicated. This gentleman, he's already outlined a pretty substantial thing. If I were to do anything, I'd go by what it says. I haven't had a chance to review it all, but I don't think he had put anything in there that couldn't be acceptable. Now, the other thing, as far as I'm concerned, I don't want to hear anything about our building Board of Health agent and her comments, or anything to review by her, period. And if she wants to come in here and argue with me about that, she can well do that. But as far as I'm concerned, she's lost her opportunity. She lost that more than a year, almost a year ago. I just think we can do this. I suppose the best way to do it would be to go through his recommended decision and see if there's anything that we disagree with it, and figure that out one way, or if we should add or something, or delete something. I mean, he's taken the time to make that, and it's pretty substantial. I mean, I can't imagine that everything we could possibly think of isn't in here. I'm sorry, that's the way I feel.
Well, let me say, Joe, I, for one, will not participate in writing a motion as, for this particular petition tonight, by all of us just sitting down and doing it, due to the fact that it's much more complicated. It takes care of a lot, there's a lot of neighbors that need protection, as well as the individual who's running the facility. It's a two-way street, and the neighbors have to be protected as much as the individual who's running the business. And I'm not going to sit down here tonight and write a motion off the top of my head.
Mr. Chairman, can we then take his motion and go by that? I mean, it's...
I'm not going to vote for it.
You wouldn't vote for it?
Nope.
Why is that, sir?
Because I'm not going to sit here while we just do it. If it's a simple thing, yes, but not something that's as far-reaching as this.
It's 4 pages long. It doesn't seem to me to be that long. I think we could handle it.
Well, that's up to the board if they want to write it right at the moment. A motion. I don't.
Yeah, wasn't it model for prior decisions that were written by?
Anybody have any comments?
Well, I might say I'm inclined to agree, what just Joe said, but I don't know that we could write the motion or be certain that this can be done in the meeting tonight. But I am inclined to agree with you that it should be done by the board, and it's about time that this moved forward. I don't think the Board of Health, I think they're a little remiss in coming this late with those letters. And should be here tonight.
I can't answer that one.
I know.
I'd have to agree with Dorothy.
So what would the board...
I'm not sure that we have to reinvent the wheel here. I understand there seems to be some issues as far as control and the fact that
DEP does not control it, but I don't think that gives us the obligation to invent legislation to rule over this gentleman's business. I'm not sure that's what we sit here to do. Now,
And
we
it
can
is
we can
industrially-
safeguard the community to the best of our ability, but I'm not going to sit here and invent regulation.
Any other comments?
I don't have a comment in that regard, but I'm trying to avoid an impasse here, Mr. Chairman. As I look at this document, and I was negligent by missing a couple of these hearings where this was heard, because it's been taking place so many times. But the key point is really the section that says the special permit is subject to the following conditions. I mean, the typical motion that we either approve or disapprove basically reads the language in the ad and then adds the stipulations that you see listed there. That's the key part. The
I'm not saying...
introductory, please, the introductory kinds of things that Mr. Wyman also added, some of those might end up in findings or something such as that, but that's the key point, right? Are we, in effect, happy with the stipulations? And it's a list of 13 on my page. That's really what it amounts to. The other parts of the document, in one sense, I agree with Mr. Freitas that we should try to make it as simple as possible so it's not subject to misinterpretation in the future.
I agree with that. Any other comments?
Well, I would echo at least some of the comments. My issue is that everything we've asked them to do, they've done. And I keep hearing all of the undercurrent about what they're doing on the property and this and that, but yet I see no cease and desist order, I see no violation orders, I see no people making visits over there and reporting before the board. Everything that seems to be a problem comes to the board 1 or 2 days beforehand in the form of a letter, which is almost impossible to react to. So I do know that we hired, at the expense of the petitioner, an engineer who went out and did the traffic, noise, and odor as we requested them to do. There were comments back and forth, and we now have a letter in the package tonight that says that they have now been satisfied and that no further action is necessary. So I can't attest to, I mean, the opening statement of our health officer was, although the site is zoned industrial, problems in the recent past with unpermitted operations, violations relative to the permitted operations and impacts to residential neighbors in close proximity clearly calls for this operation to be considered for site assignment. To me, I don't know of any. I've had no other department head shed any light on that. It's all hearsay. So, to the extent that I think it's time to move on this, and the draft decision that we have before us tonight that was drafted, I don't know what, I know it was modeled after another attorney that's written several decisions for this board in the past. And I'm not sure item for item as we go down, but I do know that the decision that's before us was given to the petitioner, his attorney, for their follow of the draft decision, the format and substance. So, I mean, I don't know what, you know, it even gets down to like the landscaping and the interpretation of zoning. That and the screening and what constitutes screening. And the plants that were selected that our board member actually approved, went to the site and did, who's been doing it for years and years and years and years and years. I'm not going to question the landscaping. So it's no different than the Cape Way rover trap. You bought a house next to a dirt bike track. There's noise. And you bought a house next to an industrial zoned piece of property, albeit vacant for a very long time, but it's an industrial zoned property. Everyone sitting on this board, I think, has been affected by either general use or some sort of a zoning industrial property that says, hey, I could have a concrete manufacturing facility right at my back door. And the Alpha One dog, that little 3.5-acre parcel on Route 28, that could have been a concrete manufacturing facility instead of a dog kennel, because it's general use. So my point is, I think we need to move. I think they've done what we've asked them to do to the best of their ability. We've reviewed it, I don't know how many times, to me personally, to the best of my ability. Am I going to try to make everybody happy? Yes. Will it happen? No. Never does. And quite frankly, if we deny the petition, I would suggest that it's going to be brought up in the appeal process and it'll just be run through the mill again. But I don't see any reason why we would deny this application at this point.
Nor do I.
I'm not going to disagree with you. I just want the motion to read the way it should read, that's all. But,
So, yeah.
and to do it,
But you don't want to draft it.
no, I'm not going to draft it, because I'll leave something out of it. I want somebody that understands it to draft it. That's all. That's all I'm saying.
No, and I understand that, but what we're saying is, we want someone to draft it, and so we gave them a copy of somebody who used to draft it for the board, and they followed that model. And again, I don't have the original that they followed, so I don't know. I do know that the sum and substance of what he's written in here lines up with all of my notes for a long period of time. And I also just heard that I don't want to use the motion that they've drafted, but I don't want to draft a motion. So where does it go if we as a board don't draft a motion and we don't accept the motion that has been drafted by their attorney? What's the only other option to do? Or what options is there left?
I said I personally did not want to sit in a committee to write a motion. If you want to adopt one of the motions that's in front of us, I don't have a problem with that.
Well,
We
we only
don't
have
want
the
to
one.
start from scratch.
Right, we
That's
only
right.
have the one.
We only have one.
We only have one.
I don't want to start from scratch, the board writing a motion. We have a hard enough time with simple ones. If you'd like to do it that way, I don't have a problem. Yes.
Good evening, members of the board. David Mnuchin, representing the Caswells. I agree with Mr. Priestley. You folks are getting close. However, I think these 13 conditions elaborated in the proposed draft submission of the applicant are inadequate to protect the neighbors and to make sure there's a clear operational guideline of how the business is going to act vis-a-vis the neighbors and to protect the town's interests. I've been before this board on another matter, and counsel was hired for the board specifically to draft a decision. I would submit a residential project like 35 East Main Street as compared to an industrial site really begs the question that that's when you really need counsel again. There's a whole different set of dynamics. Not to say we're going to deny it, but to say, okay, here are the conditions and the items the board is concerned with. We need them to be put in proper comprehensive form so that it protects the board and the community. Now, I would disagree with the gentleman, Mr. Freitas, that you cannot take any input from town departments. Input's one thing, but you can certainly, as a board, request assistance from any and all municipal agencies that you have for the purposes of putting together conditions. And I think that's a reasonable step to take if you don't want to hire counsel. I've submitted additional conditions over the course of a few hearings. I don't see any of those here. I think that reiterate again for the record, that the landscaping plan has nothing but mostly deciduous trees that are not going to screen based upon the new bylaw you have, and I think those are inadequate in breach of your bylaw, and I addressed that in the submittal last week. But it seems that there is no mechanism currently in place with this board to draft a comprehensive set of conditions, and I think that's what the board's trying to do. And I know that's what my client's interested in doing, so making sure those conditions are as comprehensive so that everyone has a clear operating plan. My client, Mr. Caswell, tells me that there was operations going on for the last 2 weeks there. The gate was open on Sunday, but they did bring in a screener. And I remember the gentleman's agreement the board had. It would just be the existing equipment, but there's been a screener brought in. I have a picture of that. Be that as it may, I think Mr. Priestley was right. We have to move on. We have to make a decision one way or the other. But right now, the conditions that were offered in this perfunctory fashion don't protect, I think, the community, and particularly my client, and that's what I'm here to speak on. So what I would urge you to do, one of two things: either engage counsel for the purpose of drafting the conditions, and you have plenty of experienced practitioners that are available to you, or you're certainly free to enlist the aid of certain department heads in town and municipal employees for the purposes of drafting, and I would urge you to do that if you still see fit. Thank you.
Thank you. Yes. Mr. Menuchyan, can I just ask a question? You mentioned that you had some, on behalf of your client, some conditions.
I submitted
You
them.
mentioned landscaping. What were the other ones in a general context?
The buffering, there was we had buffering and screening of the facility from roads, abutting
Well,
properties.
buffering, part of that is landscaping, is it not? The idea of buffering?
Well, it's landscaping, but it's usually a condition, and what I...
Well, I'm not arguing. I'm
Okay.
just looking for a
Yes,
category.
actually, I'll summarize what I gave to the board. Compost business should consist of yard and leaf waste only. The hours of operation, what they gave to the state application was Monday through Friday, 8 to 4:30, and Saturday, 8 to noon. We would like to parity that. I think they gave a little different, but it's essentially the same. The other thing I would suggest to this board is that you put in a condition, and I've seen this in other jurisdictions, that says after the plant is open for a year, not a year from the decision, but after they're doing business as a single-stream recycling plant, that it has to come back before this board for review, to review the conditions and the operational procedures, to allow you to see if it's, A, if it's working, and B, if there's additional conditions necessary. I've seen that. I've seen these special permits granted only for a year. You may not want to do that in this case, and I understand the applicant's got a substantial expense. It probably wouldn't be fair to him. However, I think it's reasonable in this case to say, hey, we want you to bring it back after a year of operation so that we can see if there's any tweaking or adjustments. I indicated that weekly cleaning should be conducted by the applicant on all adjacent municipal streets. The town may have a street sweeper, however, most of the debris is going to be falling off the trucks. It's going to be the applicant's debris. I don't think it's fair for the town to do it. I've had concrete batch plants I've represented, I've opposed, and the municipalities there have imposed that condition on the applicant that they have to hire a professional street sweeping firm, not just to churn up the dust, but to actually remove the debris from the street on a weekly basis. The other thing is, it goes without saying, but it should be clear that this board intends, after the decision is issued, that the building inspector is the gentleman or woman, if there's a woman involved in that position, that would enforce the conditions. That goes without saying under 40A. And also, my client indicated, sir, that there be, he requested there be no outdoor welding operations on the site. So those were some of the conditions that we've offered.
No outdoor. Could you say that last one again? No outdoor what?
Welding on the site.
Why is that, sir? Who said that?
That's a condition my client has requested. Outdoor welding that be done indoors.
Would you explain why?
Well, I think it adds to noise.
Welding?
I don't understand that.
The flashes. So that's a request. It's up to you whether you want to impose it.
Okay, thank you.
Thank you.
Thank you.
I don't really have anything to add, except that the draft decision that I proposed, I sent to Tammy. I sent it as an attached document. It's on your word process system. I intended to submit it as a format in a draft. I put in the conditions that I thought we talked about. Those are my conditions. You know, that's what I'm proposing. Nevertheless, you have a decision on your word processor, wherever they call that now, to add and subtract or whatever you wish to do. The purpose, one of the things that Mr. Mnuchin raised early on was the fluctuation in the zoning bylaw change. I added language in the preamble just so that everyone was clear that you were operating under the existing codified zoning bylaw, not the old one. And that is comfortable for me so that someone doesn't raise the issue that you found for a special permit based on a bylaw that has expired. That's the reason that language is in there. The summation of the facts are just what I thought transpired. The findings that I've called out are the 7 findings that are in your special permit that you're supposed to address. I mean, I've tried to make it all-encompassing to withstand any potential attack that you forgot something. The conditions, I will agree with you, Dr. Brown, the conditions are the meat and potatoes of everything, and I don't know that the rest of this stuff is not worthy of the discussion that we've had, but obviously the conditions are the conditions, and that a compromise position would be that you vote the special permit, subject to a decision and conditions that you intend to do and come back with a decision. I just don't want to perpetuate things. If our next meeting is that there's a decision, a written decision based on the vote of the board to grant the permit, I guess that's what we can ask for.
Thank you. Anybody else?
Mr. Chair? I'm not in favor of revisiting this in a year from now. I don't think this board is, I mean, once the decision's been made, once it's been drafted, and all of the conditions are written clearly in there, then it's up to zoning enforcement to make sure that it's going on. I'm not in any way, shape, or form interested in sitting a year from today and wondering if they're doing what they're supposed to be doing and we're doing what we're supposed to be doing. That's not what this board is for.
I would agree with you.
And the only other issue I have is some of the things that were, you know, one in particular I brought up at the last meeting that you weren't here. There was a controversy of the noise. And the planning department's letter said that it should be based upon residential. And it's industrial zone. And we sort of addressed it because I brought the concern up. And Weston and Sampson said, regardless of whether it's residential or industrial, that it was a negligible difference between the two. But you know, that's sort of the thing that I think is irritating everybody. These late coming things that just get tossed out there. So I don't think his request is unreasonable at all. In terms of, you know, you want to hire somebody to draft the decision, you want to give it to John, you want to give it to Dan, you want to give it to any one of them, you can do that. But I'm not sure, I read through this decision at length, and I didn't pick up anything that we haven't discussed, other than those contentious points where the abutters don't necessarily agree through their attorney, meaning the definition of screening, the landscaping plan, the berm versus the trees that Joe went out and spec'd out with the applicant. So, to me, I think we've covered this, the 150-foot setback, side setback that got taken off the table. So no longer a variance needs to be sought after. The elimination of the building so that that wasn't in the lot line. I mean, this, I don't know what more we can ask of these people with reasonably. So I think they've done everything that we've asked them to do. It's just a matter of getting this decision done.
I don't disagree with you at all. on that part.
So how do they get permitted?
We
I
have-
mean, what do we do to get them permitted and get them through the process?
We have to find out in the affirmative, whatever you're gonna, or the board is going, not you, I won't say, whatever the board is gonna put on it as stipulations, and then vote on it, that's all. Pure and simple as that.
So,
Well,
other
it
than,
sounds simple, but it's not
I
simple.
know it's not simple, but other than what was listed here, Attorney Mnuchin had a number of things, and I think we could either up or down those right now in terms of whether or not those are conditions that we think should be written into the decision. So let's
I
start.
don't have a problem with that.
Would that be okay?
I don't have a problem with that.
All right.
I haven't read any of it, so I can't say yes or no.
All right, well,
I don't
these
have
would
a
be
problem.
conditions that,
Would go on this list at the end
that
here.
would go to this list on the end if we thought, as a board, that it was important to have them there. There's 13 of them listed. It's right after the definitions.
Oh,
So the granting of the special permit is subject to the following conditions, and there's 13.
The 13, I don't have a problem with those. Going to go down through them.
Right,
Take
and
them one
I'm
by
trying
one.
to, this is from the applicant's standpoint of the things that were discussed and agreed upon. Now, there's a difference,
Yeah, this is what we...
there's a difference in terms of, like, item 2. The applicant has 7 to 5, Monday through Friday, and 7 to 12 on Saturday, and closed Sunday. I believe Attorney Mnuchin said that originally it was 7:30 to 4:30, Monday through Friday, and 7:30 to noon, or something like that.
The state application at 8 to 4:30.
8 to 4:30,
8 to noon on Saturday.
8 to noon. So that's one discrepancy.
well, we had a discussion on this, though. If I remember, and we said 7 was the adequate time.
Okay.
We did.
Yeah, no, but what I'm trying to say, Joe, is I'm not trying to find what's right or wrong.
Okay.
I'm trying to say,
Where the difference is.
Attorney Mnuchin has a list of conditions, and so don't we. And so we can either adopt the applicant's or adopt Attorney Mnuchin's with the blessing of the applicant. And I think it'd be just good, just to get them out
I
there.
don't have a problem with that.
All in one comprehensive list. So, so it's the first issue, if we just use the hours of operation, Dave, it's 8 to 4:30, and then what on Saturday? 8 to noon. Okay,
Could I throw something out to you?
yep,
Sure.
You're in an industrial district.
right,
Industrial districts normally start at 7.
right.
Yes.
That's
So
why
that's,
we
that's
had,
exactly what I'm getting at. So
Right.
I'm trying to take almost a straw poll from the board members, who wants 8 to 4:30 and who says 7 to 5 is okay, as in the decision.
I think we have to remember too, that there may be other industrial buildings going in there at some point. We
Okay.
don't know. And we're not gonna, we can't very well have some industrial at 8 and some at 7:30 and some at 7.
Right.
There's no logic to
No.
But on that issue, Mr. Chairman, we could just add a stipulation that they're going to put additional businesses/buildings, they need to come before the board. We'll deal with it then.
that. We could do that.
So which set of hours do we agree with that are more appropriate for the zoning and the business? That's really the question. Because I'd like to address every one of Attorney Mnuchin's conditions that he has requested through his
Do you want that in the form of a motion?
No, just like in general, let's just figure it out together.
Well, I propose 7 to 5
Okay.
and 7 to noon.
I'm 7 to 5.
I agree.
7 to 5.
I
Okay.
agree.
So that one sticks, number 2. Welding, on site.
Excuse me, could you put a prohibition of federal holidays or recognize that in no operation?
I think that's reasonable. I think that's reasonable, personally.
Anyone have a problem with that? Did you hear what he said, Joe?
So you'd have a statement that would basically say, closed on Sunday and federal holidays.
Yeah. Yeah, I guess so.
Yeah?
That seems reasonable.
That's reasonable.
You want July 27, 2012?
Yeah, it should be on the actual plan.
On the actual plan?
And it's going to be the one that Joe looked at, and I just want to make sure that's the one that Joe said was correct.
Yeah, but I added something that was missing.
Okay. Just pass it back down to her. She can. There's notes.
So let's go to issue number
I don't
one.
know.
Landscaping
I don't
shall
know
be
the height, though.
installed consistent with that's shown on the site plan.
There you
That
go.
is the site plan, except we need the date and the addition that Joe just read. So could you tell us what that is?
Light spruce trees at 10 feet apart, about 150 distance from building, height of trees with question marks. What's the height of the trees going to be?
I don't know what your height have proposed on that.
That was all submitted with,
The spruce trees, I don't remember them being submitted.
This is what I have.
I think they were on the plan, but I don't remember seeing it
Maybe
in
it's on
print.
the,
I'm doing the changes with engineering, I can put it on the site map, I don't. I want to say they were 5 feet or
I know it says 10 feet apart, but I don't know about the height. That's the shrubs and trees that are planted.
I'm going to ask that question.
I mean, there are some that's supposed to be added, right?
Huh?
Trees that's supposed to be added, right?
Well, that's a whole row that he's added right in front of the building. Well, about 150 feet from the building. Yeah.
It doesn't sound like an everyday occurrence.
Okay.
Well,
Well, you can put that down, I guess, 4 or 5 feet.
In the flash, you're right, and look at all of these trees, look at all the,
All right.
it's not, let's see them.
Just ask. I think Eric's doing the right thing.
Yeah.
This is what.
Oh, the J curtain, that's one like this specific curtain that cats do, so they don't have to wear their brakes out. Has to do with changing or shifting the gears, and it makes noise.
Slowing down by lowering the gear.
Yeah.
I identified the site plan.
Almost all of them say.
Go to the site plan.
There's some other things where we said they couldn't do
I've
that.
identified that site plan as that site plan.
That's it.
That's dated 7/12 conditions. So I'm referring to that, even though it's not.
Okay, with you two?
Even though it's not
I
in
just
the
wanted to make sure it was
conditions.
Really not, but it's the speed limit.
Right, with, I thought it was.
What's the speed limit on that road? You know what I mean?
I don't know.
December
I have no idea where the word is,
Because
but
if you're not going fast, you're going to lose
So 4 to 5 feet.
What's that?
governing the speed
Now, the only thing with the landscaping that we generally have
But I'm just
limits
asking,
are,
what
is after a period of time, when to be 1 year, and it's dead.
how much
Yeah,
variance you need for right?
generally,
You
yeah.
add that in
The only thing is,
You can't tell.
no, but
I'm concerned.
not to do this downshift and kind of, that makes so much noise.
Yeah, but
The regular break.
I wouldn't want to see anybody taking the trees down either. In other words, if they're cut off, I have a problem with that. I wouldn't even replace it myself. If the tree were cut off and allowed to just sit there and die, it wouldn't get my vote to replace it, period. In other words, the gentleman is planting those trees. And if they're going to be cut down, well, that's a problem for me. And the way I look at it, if it's down as that, it's a deterrent to those who might think that they would like to cut them down. But,
What do you know if
if it just dies and it's all there, that's one thing. If it's chopped off, that's another.
That's murder.
That's right.
Tree
And,
murder.
you know, I'm sure they don't want to have any of their landscaping disappear, and that's the way I'd like to see. And most of this is far enough back off the road where it just shouldn't be chopped for any reason.
What happens if it dies of natural causes?
Then it
Yes,
would be
it's gotta-
replaced.
Should be
It's gotta be
replaced.
replaced
Yeah.
within
1 year.
1 year.
Yeah.
Okay? Yep. That makes sense?
Yeah.
Okay.
Mr. Chairman, just on that issue, I know we have a difference of opinion, and I'm not going to address that. The board can act the way it wants, but just a couple of suggestions on the landscaping condition, that all landscaping be maintained in a live condition, and that all landscaping be completed according to whatever plans you're approving prior to the commencement of business operations.
Prior to what? I didn't get the last part.
The commencement or start of business operations.
Okay. I don't know how you do that, because they're running out.
Maybe, we need a time frame that would be
Running out.
appropriate. All right.
Within some time frame after the
Right.
vote of this board.
If this board approves it, let's assume within 3 months or something of approval,
landscaping.
something like
Yeah, it
that.
Okay.
would have to be in the ground before January, for almost
Yeah,
certain.
something like that.
And,
Does that make sense then?
yeah, he's got an awful lot to plant. The
Joe,
question is,
tell us a time frame that would work,
What
you
time?
think, in your mind.
he's got 900 feet of frontage.
I understand that.
3
What-
rows.
What would you guess for a time frame, Joe? You're the plant guy.
I think for trees, there's a non-planting
I-
season, June 15 to September 15, according to the State Highway Department.
Well, why don't we just take that last date and say they all got to be done as of that last date, September, whatever.
That would be next year?
Yeah, well, let's face it, there isn't that much time left in this year to plant
Yeah,
anything.
No, I don't have a problem with that.
We just want it done.
Yeah, no, I know.
So why don't we take the first date
okay.
of June, June 15th?
That would be all right?
That, you
Yeah.
said this spring?
Okay. Does that take us out of number one now?
It does.
Yes. Why don't you read it back so everybody knows?
So landscaping shall be installed consistent with the, that shown on site plan dated December 13th, 2012. Any plantings that die after 1 year have to be replaced
During 1 year.
during 1 year. Has to be replaced. The landscaping has to be maintained in live condition and must be completed by the petitioner no later than June 15, 2014.
Good.
Good.
Okay? Three, petitioner shall maintain an odor abatement plan consistent with that submitted to the board and dated January 2013. That's the one that was already adopted and approved by DEP. So I think that's okay. Anyone in disagreement? Petitioner shall maintain an integrated pest management service program to deal with the potential pest issues. That was a topic that was discussed at the health level about there doesn't seem to be detailed reports and mitigations plans for control of infestations and wildlife.
They should be subject to the Waltham.
Right, it's the Waltham chemical letter that was submitted by the applicant. They have a pest control program in place through Waltham Chemical.
Well, they only have, I believe, it's just an agreement right now that if they need one, they'll require it. I don't know if the board wants to come on or not. They only have an agreement that if they find that they need one, they'll apply one.
No, it should be an agreement.
You mean it should be a,
It's not if they find a problem.
right?
It should be an ongoing maintenance program.
I'm suggesting adding petitioner shall implement and maintain.
Okay.
That's what Walter's going to do for us. It's going to mean we're going to do it.
Yeah.
We're going to maintain it.
Okay, so the only thing I would ask you to do is on Waltham Chemical letterhead, I'd like a letter from them on what their maintenance program will look like at your facility. I'd like to know dates and times and things like that that are going to be there, and what they're going to do and the frequency of that for 1 calendar year of operation. Yep. Is that all right?
Sounds good.
Okay. Petitioner shall obtain and maintain,
I can stop 1 minute. You
Yep.
said you'd like to see the whole agreement, which I have to agree with you.
right, that'll be subject with the decision. Yeah, we'll see the whole agreement and agree to it, the Waltham Chemical Agreement.
Okay.
Meaning, they need to not just say that they'll maintain an integrated pest management service program. I want it listed as Waltham Chemical, and I'd like to know what it is they're gonna do, the frequency that they're going to do it at within a calendar year, and exactly what the maintenance program is gonna entail. And then we'll,
They're gonna start.
yeah, well, we'll start with the operation and be renewed each calendar year, that's what I
Calendar,
recommend.
okay.
Right, and that'll be
Okay.
coming from Waltham. Because I actually think the letter was pretty close to that already. So, petitioner shall obtain and maintain all appropriate state permits for the proposed operation.
May I have all state and municipal permits for the conservation work?
Yep,
No problem.
I think that's completely appropriate.
Yeah.
So what he said, state and local.
State, the petitioner shall obtain and maintain all appropriate state and municipal permits for the proposed operation. Petitioner shall obtain all required building permits from the Middleborough Inspectional Service Department.
What is that?
That's the building commissioners. So,
So should we
so
say?
meaning it's all, it's encompassing everything. It's, if it's electrical, it's electrical. If it's plumbing, it's in plumbing. If it's building, it's building.
So that includes all of
So
the,
it's all departments.
okay.
And I think I'm just gonna write that in, all departments. Inspection and service department.
Would that include inspections by the fire department or the health department or anything else?
Those have to be done anyway.
They do or don't?
They do have to be done anyway by law. It's not,
Well, that's
Yeah.
right.
you can, I suppose you could put it in there, but it's,
I actually think we already have a letter, Mr. Chairman, from the Middleborough Fire Department approving the fire suppression system that was proposed.
we do.
We do.
So I think that covers that. So, and I do know that we have somewhere, I don't know where it is, I don't remember seeing it, but I know we have a sign-off from our health officer on the septic revision that was done there. So that was done to the satisfaction, I think, of Bob Whalen as well. And so I'm not sure who else we would have to look at. Okay? You all set there, Mr. Menuchyan? Yep, you good with that?
This was on the services?
Yeah, number 6.
That's fine.
Okay.
Can I make one change to that, just to make it
Yep.
broader? Required permits from the Middleborough Inspectional Service Departments or any other municipal department.
Okay. What's that? Yeah. Well, we lost 7, 8, and 9. I don't know where they went. Oh, I get it. 7, 8, 9. You don't remember that joke?
Yes.
It must be just me.
Fifth grade, maybe?
No, it must be, I have kids young enough to
You're
remember that.
regressing, Mr.
7,
Priestley.
8, 9. All right. So, number 7,
Which is 10 here, but it should be
which
number
is number
7.
10 listed on this, but we're going to
7.
change it to number 7.
Yep.
No Jake signage will be permanently placed along the site's frontage on River Street.
Could we ask, what is the speed limit on River Street? Do you have any idea?
Is it posted?
No.
It's not posted? So it defaults to what, 30 or 35?
Fundamental speed.
30?
Should be 35 then?
I don't think
If it's not posted by law, isn't it? In the
Yeah,
state,
it's
30.
fundamental speed law.
Yeah.
If it's not posted?
If it's not posted, it's 30 miles an hour.
I don't think so. I don't think so. I think you should look that up. We can write a letter and ask.
Yeah. Well, we're talking about the no Jake signage, and someone asked what the speed limit was.
Right, I think the speed limit should probably be posted.
That's not up to us.
Could we
It's up to the
ask?
police chief.
Ask the town to post a sign, put the speed limit in. That would be the smartest thing to do.
The intent of the no Jake signage was to avoid unnecessary noise from the neighbors in the
Right.
earliest in the evening.
If you're not going fast, you're not going to use a lot of breakage.
Well,
You'd be
unfortunately,
surprised.
most truckers will use the Jake brake where they do the pedal.
I
And they
understand
just
that, but I'm
create
just
a rack.
saying, if we posted the sign in addition to this would be, I think, helpful.
Okay. The problem is, we don't have any jurisdiction over the speed
We can ask in a separate letter.
to,
Request that the
The
speed...
Public Works put the speed limit up on a sign.
It's up to the police. It's up to
That's
the-
not a
but
big
it's
deal.
it's not a part of the condition of their permit.
No.
No, but we can ask in a
Yep.
separate letter to the Department of Public Works, post
think
the
that's
speed
great.
limit on the road so it's clearly understood.
I think that's fine.
Not sure that's
You
our
might not
job.
have an answer for us.
You might even get an answer to exactly what it is.
Maybe we will.
Washing of vehicles and equipment shall take place within the building. We also have a SciTech letter addressing that, because that was one of the issues, number 8, yeah, which is shown as number 11. That was one of the issues that was discussed in the planning department's letter.
Could I ask why that is? I mean,
Because there's a tight tank to catch the runoff of the water.
I wouldn't think there'd be that big a problem from washing a car.
You'd be surprised. If I have to have trucks washed, they actually have to have a way to reclaim the water. The runoff from the truck, yeah.
Okay.
Eric?
Number 9?
Eric?
Yes.
Could I make a suggestion on that?
Yeah.
You can either consider this as a second sentence or a replacement sentence. Why don't you say it, no washing of vehicles outside the building? It'd be a lot simpler. Because that's really what you're trying to prevent, is it not?
Apparently.
For whatever reason.
Well, it becomes a question of runoff.
Well, I understand,
And there's
I understand what you're saying,
the
but
drainage in the tight tank
Instead
inside
of
collects the
saying-
water.
to do it in the building, tell them you can't do it outside the building, because that's what we're concerned about.
Right, so what I did is I just left washing of vehicles and equipment shall take place within the building. No vehicles can be washed outside the building.
Perfect.
Outside the building. 9, which is shown as number 12. The site shall be used only for the operation of a single-stream recycling facility and composting operation. Any use not consistent with those operations will require a permit from the zoning board of appeals.
Mr. Chairman, may I suggest that the second sentence we delete it, it's too broad. I think if you're approving, it's just the first sentence and then the 12 below 12. Because now you're getting into what's consistent and inconsistent.
I agree with Mr. Menugian on that. I think that first sentence period and strike the second sentence.
Strike the second sentence.
Good to go? Out. Number 10, which is shown as number 13, the petitioner shall demolish a portion of the existing buildings along the easterly sideline that encroach upon the 150-foot side setback requirements of the zoning bylaw. That was what you agreed to.
Eric, why don't you use the word "any portion"?
I'm sorry?
Put the petitioner shall demolish any portion. It'll read better.
Okay. And then, thank you for reminding me on that, Tammy. The issue of the street that's there, what's the name of the other street that goes up there? Auburn. Whether or not that's an approved street, and you have to be 150 feet from that street, you agreed to move that stockpile.
That's on the site plan.
And that's also on the site plan. But I think we're gonna spell that out, that no operating within the 150-foot sideline to Auburn Street, okay?
Mr. Chairman, can I suggest that we simplify it by just adding that no business operations can take place within 150 foot, any setbacks required by the zoning bylaw?
The only problem with that is parking up there, if a truck out there, a car out there, park, it's asphalt, I mean, it's not,
That's what a setback is. It's not supposed to be any use.
no, that's not exactly what it says. It's saying nothing can happen.
My only problem with that is almost every industrial building in this town that has a 150-foot setback, has a parking lot in the front of it, has access to the building. To say nothing can go on there is inviting, in my opinion, would be, if you're parking vehicles in there, that would be considered a use and creates issues as far as compliance. Are you using it, are you not?
Mr. Chairman, I'm not objecting to parking and things like that. I'm just saying, though, business activities from the recycling plant should be conducted in a setback. So equipment shouldn't be here, it should be a setback. If it's parking, or accessory use parking, that's fine. But
Okay, well, I just,
think it should be a business use within the setback.
Well, I'm just trying to think how we would word that, so, and just so that we're clear, so it's not a parking issue or whatever.
Just put,
to be able to traverse across it, you have to be able to access the site.
Right. No, but I think he brings up a good point. There's one thing to park there, it's another thing to operate within the side setbacks. And I think we agreed, you agreed, to remove the building so that that wasn't an issue on one side. You moved the pile so that that took it off the table for another side. But I think the issue is putting something in there that says that you can't operate your business within that setback.
and I think you just had, no business operation shall take place within 150 foot, within the 150-foot setback. Business operations aren't accessory uses that are allowed in the bylaw.
I'm not so sure that there's nothing in the truck that's parked. I know it's for a fact, 150 feet, that's going to be loaded with material and that stuff. I don't think that they need that potential. A truck will be there, but the load with alcohol, a composting and fire, it's no to our site plan. It may be a situation. I just don't want to have, well, the policeman out there saying, well, we've got a truck. Parking is allowed. Take that, and it's all it out. Clearly understood, we're not going to do any operation consistent with our traffic.
Okay, yes.
What happens if you add another one? Just say that parking is allowed within the 150-foot setback.
Well, I actually like both of
What would
those.
you like?
So I think we should put, and then it's up to the petitioner to have to operate that way. He's already agreed to the side setbacks.
Yep.
So I'm assuming that none of the operating activity would take place within those setbacks. That's why the setbacks are there. So I think no operating of any business activities within the setbacks is all that needs to be said. And then in addition to that, that doesn't include parking. What did you call it? You called it something.
Accessory off-street parking.
Accessory parks.
Remember, I was spreading out the street. That's got a stand of mature trees on it.
Yes, it does.
Hiding our site from what's going on across the street.
Okay. All right, so the petition shall demolish any portion of the existing buildings along the easterly sideline that encroach upon the 150 side setback requirements of the zoning bylaw. And we just took and put, there will be no operating of any of the business activities within the setbacks and does not include accessory parking. Everyone okay with that?
Let me ask you a question.
Yep.
When is the building to be demolished?
How long would it take you to knock it down? Month? 2 months? Why don't you put a timeline of a certain date, a couple of months from now?
petitioner shall demolish any portion of the existing buildings by, how long do you want?
I'm just suggesting, it said 2 months, so I say
2
2
months,
months
that's
from now,
about-
whatever that is.
Is that
End of
enough?
the year? End of the year?
How about, yeah, December 31, how's that? That's more than enough time.
Depends when we approve.
Okay. All right, so can we now look at, just, I'm trying to go by memory, so forgive me if I miss a couple. Welding,
Inside-
welding outside.
Welding inside unless public safety is involved.
Can I ask how much welding you do on your property normally?
You can't speak up
Wait
like
a
that.
minute, wait a minute.
You just can't do that, okay? We go over this almost every meeting. You can't do that.
I think any welding that has happened is apparently, that's minuscule.
Are you unhappy with the idea that you can't weld outside?
No,
It's not an issue.
No, we shouldn't.
So you want to take Dr. Braun's approach and say welding can only be done inside?
Or what if you have public safety involved, like a
Then
vehicle
have it done
pinning
someplace
down
else.
one of your workers?
I'm sorry, what was that, sir?
I say, what if public safety is involved? A vehicle has collapsed on top of one of your workers, to get a welding hook to lift the vehicle to free the,
Well, that would be-
The fire department, that's public safety exception, that goes for anything. Certainly not going to be checked.
If somebody's lying half dead under a vehicle,
You're going to get it off there any way you can.
if they do, there's something wrong with it.
So number 13 would then be the street sweeping and street maintenance.
That seems a little
Well, that would be number 13, yes. The new number 13.
Have we ever required a business to clean the streets?
Not in
Any
the
of
13
that?
years I've been on the board.
All I can tell you is that the landfill operation sends a person out once a week to pick up any paper on the edges of the highway for some, I don't know how far back.
Around the landfill?
Yeah.
I think something like, I don't know about a week, but something like that is reasonable. You've got recyclables coming in there, and potentially open trucks with paper goods and/or bottles and/or, I don't know what.
I don't think you have to sweep the street,
No, I don't think so either.
but I think you have to pick up the side and
Hey, I mean, you gotta clean up a little bit after yourself. I think that would be kind of like a normal business expense. Are you doing that now, by chance? So how often do you do it?
I see trash that's thrown up on our property, I go and pick it up, I don't like to see it.
No, I understand that, but I'm just saying, how frequent is it?
There's no trash out there.
Can I make a suggestion that as part of the operational plan that you indicated in the prior condition, that should refer to the pest management plan, you should also put something that he has to come up with a maintenance plan submitted to the board before he opens, that details what he's doing for cleaning the site. I think there's a reason.
Well, the only other problem I have with that is, I live down in South Middleborough, and I live on Rocky Gutter Street. And I have to cross over Route 28 to go to Miller Street, okay? And people either at the end of Rocky Gutter Street or on that tiny little stretch of Miller Street use it as a dumping ground.
if they slow down,
Okay.
they throw it out the window.
My point is this, I don't think it's fair to ask A-plus Waste and Recycling to be picking up literally everybody's trash.
Well, I agree, that's why I was trying to deal
So-
with the street itself.
Yeah, I understand that, but he should be held accountable and responsible for that which is being produced that comes as a result of his business operation. So if someone doesn't cover a load correctly, or they don't fill the back correctly, and it's part of that business activity, that's one thing. But I don't think it would be fair to insist that he develop this maintenance program that's gonna be clean and green all the way down River Street.
No, that was one pertaining to his site.
Okay.
Which a component that should be, if there is a droppage or anything from his truck coming in and out.
For material consistent with his operation.
That's fine. I just don't want the word maintenance on the road for them.
So how do we word this?
I think the way it said it was pretty consistent.
Yeah, I know that, just about how it's
Just say the applicant shall submit to the board a maintenance plan that deals with on-site cleanup operation.
I think we should be able to just
We will
put,
police our property, we'll pick up after ourselves as we do now. I don't know,
I think the concern is that they want it written into the decision so that it's part of the permit.
Right.
So there's a, well,
Not at all.
I don't think it's an unreasonable request.
and, you know, litter and materials consistent with our operation shall be continually removed from the frontage on a regular basis, no less than
Okay.
every 2 weeks, or I don't know.
that
That's fine.
sounds good.
It's gonna do it anyway.
So the applicant will police the River Street property to, Auburn Street, obviously, to pick up any trash that comes from the operation consistent with their recycling. Okay? Does that do it?
How do you know who that rubbish belongs to?
Regardless, if it's on his property, he's gotta pick it up.
Yeah,
If it's not on his property, that's a town property.
that's right.
Well, if it's consistent with his operation and is on the other side of the street,
You gotta be reasonable.
but just be reasonable.
Okay.
Can I ask a question? How is the load coming into you? Are they baled, or are they just coming in loose?
In enclosed containers over that covers over the top of the truck.
But it's basically a roll-off?
It could be, what looks like a front load truck.
Yep.
Which is good steel.
I'm familiar with trucks.
I'm sorry?
I said I'm familiar with trucks.
Okay, so they're in front load trucks, roll-off containers that are tarred.
Mhm.
Yard trailers that are
Yep.
tarred. I mean, that's all DOT too, I mean, those drivers, they can't go down the road.
Yeah, but you and I both know that it does happen.
It does happen, yeah, but it's not deliberate.
Okay. No, I just for my own edification, I wasn't sure if it was coming in some kind of pre-processed manner.
Okay, oh, Mr. Menugian, I've now exhausted my memory. Did I not write anything?
You're close, sir. There was one other one. The compost business should consist of yard and leaf waste only. I believe that's what this, kind of tells me.
Yard, oh, but they have cranberry, oh, I don't think they do.
Is that too narrow a scope?
It is, we were taking ocean spray as pumice, I don't think that's legal yard, but we're taking in their material and
Yeah,
adding it to the composting operation. There is some material that we have in the past, our permits permit that 30 tons, so that's not as strict.
From our perspective, I know the odor control plan, but unless you know what's going in there, it's hard to develop an odor control plan. When I was here, it was represented it was just going to be yard and leaf waste predominantly. But if there's other things that are allowed to come in, it could just very, either knowingly or unknowingly, just shift the balance of what's going on there and the actions, and now we have a problem. So, we need to know what he's doing there. If it's yard and leaf waste, that's one thing. But I think this board should ascertain before it grants a permit, what are you going to be doing there, instead of just giving carte blanche. That's all we're asking.
And I think what I heard was yard, leaf, and ocean spray. Is there anything beyond that?
It's the base cranberries, the pumice, permits for the DEP are for up to 30 tons a day of organics. That includes the ocean spray material. So it's very restrictive in that it's only up to 30 tons.
And I think our odor, our ESS and the odor had that component when they factored in the odor issues, which is the, is that right? Yeah.
Well, can I ask what, I understand that it's coming from ocean spray, but organics could be a lot of different things.
But it's restricted by DEP to 30 tons per day. It's not wide open.
Per day. So does, let me ask you a
Up to
question.
105 tons per week.
Does the DEP have a definition of materials that qualify under organic?
Organics are defined by the DEP regulations.
The whole spectrum is all changing on DEP and knows damn well this.
I think we have that in the back. I think we provided.
Somebody asked.
Can you go to the microphone, please? They can't hear you. Sorry.
I'm Mike Feinblatt from ESS. We did the impact assessment. At some point in the process, somebody asked the question, what organics meant, and I provided the definition of organics from the Mass DEP. It's defined explicitly in the regulations as to what it, and I don't have the definition on the top of my head, but I can,
Okay.
it should be in the packet, and I can certainly get it for you.
Yes, if you would, again, I hate to ask you, forward
Sure.
a copy of it to Tammy.
Sure, no
And
problem.
so the material that you're discussing is permitted under DEP regulations as organic?
Yes.
Okay. And nothing else is going in there? Nothing else will go into the site, other than what's permitted?
I think that's what the objection is, though.
What?
If you want to just as cranberry and cranberry bitter, that's one thing. And then all other organics, it's only 30 tons per day. That's a lot of revenues.
But again, it's defined in the regulations as to what organics are.
Yeah.
It's not anything, it's
Well,
it's what it's defined to be.
And if it's an odor issue, the studies that we did that were approved by your peer review had to do with that definition. They said that the odor issue was a non-issue. We have an odor plan. DEP monitors that.
You serious?
I just don't want a policeman coming and looking in the back of our truck and say, oh, that's this, that's that, that's that. It's just not going to work for us. Because we have had that happen in the past with previous statements.
30 tons isn't that much. Oh, absolutely, especially.
Okay, so, Mr. Chairman, in my view, in terms of the material, he's requested DEP permitting for that material. He's been granted that. He's got definitions as to what it is. He's got a maximum that he can have each day.
That's it.
That's it.
We don't have any authority beyond that.
With that, you could run by it with that definition.
Okay.
And
So-
whatever they have set in the court.
So then the only-
But we should list exactly what that is in case DEP decides to say, okay, we're going to up the number of.
Well, we have-
Organics as defined by the Mass DEP.
Yeah.
Yeah, we could leave that wording.
Yeah.
Let them define it.
And set the volume that's supposed to come in. In case they suddenly go from 30 to 50.
30 tons sounds like a lot, but it's not.
It's not enough.
That's about
It's
a
not.
truckload.
That's about a truckload. 66,000 pounds.
60,000 pounds, that's nice.
Yeah, but it's one truckload. It's not, it's not.
They're not going to get in there back yet.
I can't bench press that, Chris.
It's not going to be that way.
Okay?
Yeah, please. I believe for the term.
Material as defined as organic by DEP along with the review yard list. And we have a copy of the DEP on file here. Wait, we have that shows their 30-ton.
I believe so. If it's not on the cover.
You don't, want to just make a note to give us another copy just in case. So then the last two things, so I think that addresses. Oh, come on now, you said one other just a minute ago.
It's my understanding that that whole area of the town is on well water for potable water. What I would respect to suggest is that the applicant be required to submit every 6 months a well water test. So he's monitoring his own well water, not the neighbors. So we can see if anything's seeping in, because obviously he needs clean water. But if there's a problem there, then, you know,
It could be.
the Board of Health it could be leaching off the site.
The whole back of the site has monitoring wells in it because of the DEP cleanup. That water would be, I guess, part of that. There are existing monitoring wells in the back of the building.
No, I can hear you fine.
I'm sorry. I'm sorry. There are monitoring wells in the back of the site. Basically, they were installed when the site was cleaned up.
And who's monitoring them? And for how long?
Golder and
There's approximately 10 monitoring wells behind the building, which would be on the north side of the property, which is down gradient. All that slopes back towards the Taunton River. Golder Associates is the LSP that was in charge of the original 21E cleanup. They're monitoring those wells, and they're on schedule. I can get it in writing and have Golder send it to you, but I believe they're on schedule to monitor those wells for at least another 3 years.
And who has hired them to do that?
They were hired by MRO LLC.
Which is the prior owner
Which was part of the agreement when we purchased the land, that they would clean it. and
that
monitor.
expires in 3 years, the well monitoring.
I believe so, but
I
I'll
think
double
the
check
issue
that.
is to take it.
we'll test our well. Our well is in front of the property. Excuse me, Mr. Priestley. Our well is shown on the site plan, it's in the front of the property. We want to put an obligation of us testing that water annually. We'll be happy to do it. As I say, we're all down gradient, so we don't have a problem.
And what do you call the people that are certified that, what do you call those
Just for the
people?
testing of well water pursuant to the applicable Board of Health regulations.
Say that again, David?
Test the well water
Yeah, annually.
pursuant to the applicable Board of Health regulations.
You okay with that? Are we missing kickoff? Oh, jeez.
Half an hour ago.
Sorry. All right.
So that's the 12.
10-6.
So that's the extent of taking the abutters and the applicants combination and bringing the two of them together. We now have 15 conditions. The only question left to me is, do you want to review the letter from the planning department of their list of concerns along with the list of the health department's concerns, and see if there's anything that we should be discussing there as well? Some of the planning department, I'll just give you some flavor. Traffic study was already done, noise study was done, odor study was done. Operational capacities to be identified, including the number of vehicle trips, that's all been done. That was actually in the traffic study. The health study of composting recycled material for air emissions and mitigation, that to me is all under DEP control. Buffering and screening for the facility from roads abutting properties and adjacent natural resource areas, that we've already done with the landscaping plan. Drainage study to determine the proper control of surface runoff, water runoff. I
You want to read that one again?
Drainage study to determine the proper control of surface water runoff. I think it's been running off for a long, long time. Right, SciTech did address the groundwater study to determine the impacts and mitigation for adjacent private water well. We just decided what that was on number 15. Facility discharge from truck washing and unclean recycled materials, that's in the SciTech letter. Environmental impact study for Conservation Commission related issues and mitigation. I think there was one issue, as I recall, the wetland delineation line did move, Concom was involved in it, they signed off on it.
No, they're going back to Concom.
You are going back?
They're not completely Concom.
Okay, well, so this is subject to their approval anyway, right?
I want to make that motion.
Well, let's make it a stipulation first.
Does that include Mount Furnace?
I actually think you can't do it without it, but.
No, they can't.
Yeah, but that's okay, it doesn't have to wait. I don't have that restricted. Okay, compliance with the zoning bylaw, we'll never agree on that. I believe, in terms of the, what constitutes the screening and stuff, but safety and security provisions for the facility. And I think from a safety standpoint, we do have a sign off on the fire suppression system. I don't know why, the security is in there. I do understand the safety is in there for a reason for fire, but I'm not sure what he meant. But anyway. And then storage provisions for composting recyclable materials, methods to prevent blowing of litter and use contaminants such as rats, skunks, seagulls, and insects, including but not limited to flies.
A lot of it.
Did you get that, all of those? And then it goes on to say that the two concerns with how the noise was analyzed. And that's been addressed in the sign-off from Weston and Sampson. The study does not appear to address the impacts of noise on wildlife habitats located toward the rear of the property along the Taunton River.
I'm not sure if they were complaining to be here.
So I don't know if there's anything else in that. And then, obviously, there's the letter from Gene Spalding yesterday.
You have another copy of that letter, Mr. Chairman?
I don't know how to address the last part, go to the current part of that.
I'm not sure we need to.
I don't think we need to. It's dated way past the time.
It's an awful lot of opinions, as far as I'm concerned. Can you speak up, please?
And it offers a lot of opinion, not a lot of facts. We keep revisiting old issues that have been addressed.
So I think, anyway, I think what we've done is we've now framed out a 16-point condition. I have no idea about the draft language. I'm with you, Mr. Chairman. I have no clue of how to write them, what to say. But I do know of the most important things being subject to the following conditions. I suppose, I don't know, but we now have 16 conditions, and we seem to have narrowed the gap between their desires and the applicant's desires, and we now have that done.
So now we have to put it in some kind of formal, say, written, not just letters. I mean, assuming you wrote those.
I did. I wrote them down. I don't know if everything I wrote is actually the way you would want it in a decision.
So we should get that and approve it.
Yeah. So I guess
And formally vote on it.
Who would write the decision then with these conditions and make sure that the language is accurate?
She can do that.
Okay.
And send it out.
Eric, you know what I think you should do? You just take the language off the ad, like we typically would do. Say we approve the application with the following stipulations, and then list that long number. I think the only thing that's a little queasy in my mind is the exact verbiage, because we're kind of struggling here to get the wording proper. So an idea might be to kind of prove it tentative to getting the language right.
Is that acceptable to the rest of the board?
I don't think it should be, we should include all this other things. Many of the things that were presented by Mr. Wyman would basically end up as part of the findings. When we approve a permit, we also have to approve findings, and a good deal of that document, to me, is exactly that. All the ideas about fire suppression plan, odor abatement plan, that's all in the record. That's in the official record already. We don't have to repeat it here.
So are you, everyone okay with doing what Dr. Braun just said? Did you know what he said? Just do it based upon the legal ad up front.
Add the 16 items that you
To
added.
these following conditions. And that would be put into a final decision and then signed off at the next meeting. Is that acceptable?
That sounds good.
I lost you in the last part of it.
Well, we can't, obviously,
We can't vote.
We can vote on the applicant's petition,
Right,
subject to these following 16 conditions,
right.
and approve it. But that in and of itself is not going to be the mechanism which allows them to go and start it up. It will be the finalization of the finished decision, all typed up, language exactly as we want it, and signed off on.
You can't vote to approve it tonight, because I only have 14 days to file it.
Oh.
If you vote to approve it tonight, subject to that, that's what's going to have to file with the town clerk. So you're either going to have to continue it for the final decision, or you're going to have to approve it subject to it.
That makes sense. If you're going to look at
If
it,
that's the circumstance, why don't we do this? Why don't we write it up as we're talking about it, basically using the language in the ad, add the appropriate language for those 16 or however many stipulations they were, bring them back and put that as the first item on our agenda at our next meeting. And then approve the package just like that. And at the same time, once we get them written up in the proper way, Tammy can get a copy to Mr. Wyman and Mr. Menugian and anybody else that's interested. And if there's a complaint about it, we'll just handle that at our next meeting right in the beginning.
That's the only way to do it.
The simplest way.
In case they see something.
The other things we'll put as findings, right? We'll meet all the various,
26th?
yes.
whatever it is.
In a couple of weeks?
Yep. It is.
So we just need a motion to continue to the 26th,
So moved.
right? Dr. Brown and Kenny?
Yeah.
So,
So what date?
September 26th?
25th?
26th.
26th.
Yep.
So moved.
Is that a motion?
Second.
All in favor?
Aye.
Opposed? So voted.
Kenny, you want me to type these up and I'll send it to you?
Hey, Alex, how are you?
Thanks for work.
Good, maybe this is going to finally have a resolution. Andrew,
It is complicated, so you got the language right.
Right, I'm not in tomorrow at work, so.
really?
But I don't think he's...
Oh, I have a very busy day tomorrow.
Yeah, I just
I have a roof quote in the morning, vinyl siding in the afternoon, and moving tables in the evening.
Your own house?
No, for my neighbors.
They could have something called work.
We got something else tonight?
Yeah, one more.
One more. But we have findings only on the,
Findings
Accessory
only on
apartment.
the apartment.
We have one more.
Nice colors on your printer.
Thank you. Hi, good evening, members of the board. Michael Kiley with the Heritage Companies, also with 35 East Main Street LLC. We were before you a couple of months ago regarding the rent-up of the affordable units. And what I had Mr. Mnuchin pass out was a spreadsheet of mine that shows the affordable units to date. And as you can see, of the 18 units that we've had, first of all, I want to regret, I'd rather not be up here today. I really would much rather not be here. I know. It's been a big concern that the project has been a success for the rent-up of the market rate units, and as I told you last time, it's been a real struggle with the affordable units. And as a developer, and as most developers, they take the affordable component of the units and they almost assume instantaneous income. And it's never down on the income. It's always a waiting list, and they're always filled immediately. But you can see in this process, it's been very far from that. April 1st is a date we use, even though we've gotten quite a few C of Os in March 1st, but conservatively it was April 1st. In the very beginning, it was supposed to be online March 1st with the affordable, with the Middleborough Housing Authority. It got pushed to April 1st. They were behind on a few items, and they had the lottery, and we didn't get anybody. As you can see, April, we open up March 1st, quite a few of the units. April 1st, nobody in. We get one person that comes in May 1st. They have been there through August, and they just recently moved to another unit. That's why you see them stop in September. Then somebody moves in middle to the end of June. So April, May, June, we have 1 1/3 people move in. We met in June. We took a more proactive approach, like I told the board we would, and we have now filled up, of the 18 units, we got a few more in July, one that was the original one, but we got 3 more in addition to the 2, and then after that, we got, you can see the track record as we go. And we're sitting here today in September, in the middle of September, which we'll have another one move in a couple days this weekend, and then we get 2 scheduled for October. With all this said, that's really only 66% leased up on the affordable component. And what I tried to show you down bottom is the loss of rent to date. The loss of rent from April to the day today has been $96,000. And the projected, the way we're going right now, is to lose another $20,000 in rent before we get to the year end. Now, I know the board's concerns, I know the town's concerns, I know we agreed to this, but when is enough enough? When we've done everything in our power to rent it, we've gone through with the Middleborough Housing Authority, and it hasn't seemed to work. And I've talked to a couple other different cases where this has happened, and the town gave the units back. Unfortunately, myself, my attorney, Mr. Mnuchin, came back before the board in June, a little bit just on a friendly talk. We weren't able to get on until September now, on the board, so now we're at 66%. Even if we got them all rented up, even if we got them miraculously rented up by the year end, and that would be losing over $100,000 in income, I'm not convinced that when some of these tenants get checked out within the year and they actually exceed the income requirements and have to move out or they leave, I have no evidence whatsoever that we're going to have any type of a waiting list to replace these tenants. So obviously that's a huge, huge concern of mine, because we're in the process of trying to put permanent finance on this, you know. As a developer, you get a construction loan, you put up a permanent. I most likely would have been able to put permanent financing on this a few months ago, but I haven't been able to because I need to get the proceeds with the income. So I'm sitting here baffled. We don't typically do affordable, this is a friendly 40B. We typically don't do that, our firm. We typically do market rate units. So I'm looking for a solution to either request some units given back to me or some other avenue to make up for the difference in the income.
I guess the first question is, you may be forced to file an application to amend the previous decision so that we reduce the number of affordable units. It's going to 18 now. We've got 67% of those rented, but you have to understand, these weren't really rented through the housing authority. Michael went out and did his own breeding bushes, etc. So we got some people in there, we helped them fill out the paperwork, but we don't know if they're going to pass muster in the future. Their incomes may go up or down. And most affordable projects are done, the traditional 40B is a long waiting list. We have none. And that's a concern going forward in the future, and it's a concern for our financing, because our bank looks at that as, if we told our bank we had 18 to 20 units that weren't rented, that's below our ratios, that's a violation of our loan documents. They give us some leeway on the affordables, but the thing with the affordables is everyone thought that would be the first to go, but it didn't. So I guess on the straw poll, my question would be, would you look favorably, and I know you can't make decisions, but we're probably likely to come back with an application to amend.
Microphone.
Sorry. Can I ask a question? What does it take to qualify in the town of Middleborough to be affordable? What would be a target tenant that you would look for? What would be their characteristics?
The requirements in the affordable,
for this particular project?
What
would their income level be like, family, all that kind of stuff?
Yeah, it's not classified per the project. It's classified to a median income. And what they do is, there's a Boston PMSA, and it's guidelines through the Department of Housing and Community Development of Mass.gov has those guidelines. And 80% of the median income of this area, it ends up being the rents that you see in there for the rents. What they do is they take a calculation of the income for one-person limit, two-person limit, and three-person limit.
What are those numbers?
Those numbers, what it ends up equaling out to be are the rents for the two-bedroom, $11.85, and the one-bedroom's $9.37. Those numbers...
No, I understand that, but what are the qualifications? How much money, if I was, let's say, a small family, maybe I got, parents with one child, what is the total income that particular tenant would have to qualify for this?
It runs about $54,000, I think it is. 40 to anywhere from, depending on the amount of people, it's about $45,000 to $60,000, I believe.
So Middleborough citizens with a family income of between $45,000 and $60,000, you can't find anybody in that category? That's what's puzzling me.
You're preaching to the choir here.
They take the median income, and it's 80% of that number.
Correct. They reduce
So it's
it,
actually lower than the number that you're tossing around in your head. It's lower.
But
The
Yeah, no,
income
I-
requirement for the tenants.
somebody qualifies these people, right?
Yep,
When they
theoretically.
qualify them, they must look for numbers.
they
do.
What
They
are
do,
the
and-
numbers they use to qualify
It's
them?
interesting, because the last time I was here, there was a comment made, and and a lot of people felt like this. It's a very, very tedious process that the individual has to go through, and I've heard a couple comments from here saying, I probably would just go for the market rate, because you basically get raked over the coals. You gotta give 3 years of tax returns. I mean, you gotta give a lot of information, as opposed to a normal application process where you go through a credit app and you get a landlord reference form
All right,
on the market
I
rate.
understand there's a lot of bureaucracy, but I'm still coming back to the bottom line. How much money does a small family have to rent this? What are they looking for? You must have some
It is.
concept.
I do have the
It's gotta be a
guidelines.
target.
I had them on me, but I do have them on my phone. It's approximately
I wouldn't doubt that at all.
$40,000 to $60,000 on the guidelines. And I can, if I have it right here, I'll look it up again.
So you're looking for somebody between $40,000 and $60,000, dependent upon dependents.
Typically, rule of thumb, teachers. Teachers have fit into that category 9 out of 10 times, is predominantly where that fits in. Usually teachers. Teachers are good classification.
Mr. Chair, can I ask a question? Sure. What did the modification to this building, putting in the interior garage, cost you? That wasn't on the plan.
Well, that was a conscious decision to do because of the
Oh, I know
commercial
that.
component, yeah. I don't know what the difference is in cost, but I don't know
Ballpark?
exactly. Ballpark?
Pretty-
Remember,
pretty
those were gonna,
extensive.
it wasn't necessarily too much of a increase because they were gonna be units. Originally, those were gonna be residential units. And what we did is we cut back our units to do the garage. So when you look at it all said and done, the garage was probably cheaper to do than the residential units, but we lost units, so we lost some income.
Yeah.
And we felt it was best bet to do the garage because we really didn't like the way it was situated after going out there and seeing the grade and everything else and where it is in the back of the building. Because in the back, there's actually like a window well, and personally, I didn't like that for units. So that's why we changed it. There was a lot of decisions in that, when we made that decision. There's a lot of factors made in that decision, but technically, the garage would be cheaper than doing the full build-out of residential units.
But that doesn't show on our plan anyway.
Oh,
No, I mean, I'm not bringing it up to rehash an issue that was.
There was a change that took place that not without the board's knowledge.
Consent.
that's right.
Yeah.
It was an after-the-fact presentation,
Yeah.
Correct.
which,
'Cause
under
I-
normal 40Bs, that would have constituted a substantial change.
That's right.
And would have triggered the requirement of another hearing.
Right.
And board approval. But planning, I think planning and building and the petitioner had done that sort of on the side.
But what we have does not show anything.
No,
Well, if it does, we come back and have it approved.
yeah,
Yeah,
after
it's
the
an
fact.
afterthought.
After the fact.
Yes.
It does not show on the original plan.
No, but I remember clearly one of the biggest factors in the hearing was people were concerned with people parking over in the commercial lot and walking across the street. That was one of the, and that's why, that was another factor in the decision on doing the garage.
How many units did you lose when you did the garage?
I want to say there was probably 8 or 9 units down there in the garage.
That's pretty substantial.
That's a good hunk of rent.
I guess I'm going to think out loud here a little bit. I'm not sure that there's a mechanism for us to give back.
No, we have to go back to phase 1, go through the whole process again.
We've done 40Bs for a long time. This is the first time this has ever come up.
I would
As my
make an
personal
additional
experience.
comment. I don't know if there's a mechanism or not, but at least from my perspective, there's no sympathy for it.
That's right.
Why can't you simply lower the rent?
Well, right now.
I mean, it would be not as much income, but it would also not be as much of a loss.
Right now, we fall under a certain agreement where we did the 80% of the median income. So I haven't looked into looking at lowering it. I was looking in ways that we could actually complete the process, and we thought we'd hit it hard the last several months, which we've hit very, very, very hard.
Yep.
And we have done some additional rent up, but still not at the pace where we would do our market rate units, or at the pace that typically a lottery process would bring to this level.
How long is your lease period? In other words, it says lease and rent. How long is that? 2 years, 3 years?
So what you're looking, typically we have to do on the affordable a minimum 12-month lease.
12 months?
Yeah, they're all 12-month leases, yeah.
If, let's just say you lowered it, or could lower it 150 or 200 a month, for a year or so, it just seems to me that that might get you filled for one thing, but then, you know,
I don't think you can just randomly lower affordable rents, because you have to meet guidelines per the government and DHCD guidelines. If you do that, you'd maybe have to go down a whole bracket different than what the 80% median income is. You might have to go to the low income level of the 60%, but you can't just voluntarily reduce rents.
well, the reason I'm saying that is that it seems to me that maybe this rent is a little too high for the person in Middleborough to afford it. And I don't know, I'm just a regular person. I just have no idea, but it seems to me that if you could look into that and you could lower the rent, say 150 to 200 a month, at least it would give you a substantial amount of income rather than a substantial loss in the course of the year. And then with 1 year period of time, you could raise that so much per year, I think you could get back.
Well, I wouldn't be opposed to lowering some of the rents if, I mean, should be a little bit, if let's just say there's 18 units and I were to lower 9 of them, then I would say, then why not give 3 back to me to accommodate the 9 that I'm going to lower? You know, this decision, the affordable constraint, when we came in here and we talked to the planning department, everyone, it was a friendly 40B, and those were the numbers that were dictated to us and what the guidelines were dictating. We accommodated, and we were told that the MHA was going to do this process for us, and we've all tried, and we're realizing it's not working.
Yeah.
I want to try to come to a solution where this works amicably for both of us. I would hope that we could try some other direction where we can go with this. I mean, yeah, obviously I've lost a lot of money already, yes, but I'm trying to move forward with limiting that amount of money lost on...
Has the commercial side been rented yet?
No.
Well, I guess fundamentally I have a problem with the way this comes to us because we're ill-equipped to guarantee you a profit. We're a licensing board and a permitting board in that sense that we permit the projects. We assume you've done the due diligence on your part as far as you know what you're doing as far as a developer. You've come to us with a proposal of building this project, and we're here to permit it or not permit it, whether the use is appropriate or not. Under 40B, we have to sit in other boards' venues because it's a one-stop shopping deal, but we're not here to guarantee you a profit.
No, and we understand that, but the quid pro quo for this project was, we told you we just do market rate units. You asked us to consider the friendly 40B to get some affordable units, and we did, and we worked hand in hand with the housing authority.
And you got concessions from us in the building code.
But the problem with the housing authority is they just underestimated the demand that they have in their community for these type of units. It's just not there.
I wouldn't disagree with you, but, you know, we're mandated by the state. It's.
And, you know, so, yes, we can do it, but, you know, for the long-term viability of the project, we assume that you're pleased with the way it turned out, that we're happy, we had no doubt.
It looks wonderful.
We have no doubt that the market rate units would go, but we're just asking for a little assistance because, quite frankly, it's not coming from the other town boards, and the reason why we're before you as a licensing authority is that it's in the license that how many units it will be. So before we can, you know, go to the state and say, hey, we're only going to do 16 units, and 12 units, or whatever number it is, this board has to make that threshold decision. So, yes, you are involved, because it's in the special permit.
Well, we're involved to the degree that we permitted the project. I don't know that we're involved, that we're actually sitting here discussing ways for you to make money for this.
Well,
I'm uncomfortable
it's
with
not a
that.
question of making money, it's a question of getting them rented, because, you know, we need those units rented. We can't have in perpetuity just going on and have these units unoccupied. You know, even if it's something we'd have to check into this, that you'd say, if they're not rented in a certain period of time, you can get a temporary waiver so we can do some of the market rate units. Something, because it's a shame to have these things just empty. You know, we're not trying to be greedy here, we're just asking for some assistance.
I don't disagree, but I'm not sure, I suppose we could put the question to our council, but I don't know of any mechanism for us to do this.
Well, what we're asking for is either,
even if we
we
decide
don't want to
we're
be in
going-
we don't want to be in violation of our special permit. So we would either have to have it amended by you in some way, shape, or form. So the amendment would be either reduce the number of affordable units, or if they're not rented in a certain period of time, you have a waiver so that you could rent them until such time you've got the stockpile of affordable families. I don't know, we're willing to work with you on this, but we're asking for assistance. We're not asking you to make us money, we're asking for assistance so that these things don't sit empty, that's all.
So one of the things that we've done in the past on a few 40Bs is the minimum guidelines is 80% of the median income and 25% affordable. We've actually written decisions where we've taken the number down to 70% of the median income and a higher percentage of affordable, and done a combination of that too. To me, you haven't demonstrated that you've done enough to figure out where you need to be in terms of what will make these fill up and at what price, and what could you change on your end, because your issue is with your lending institution, not with the board.
Well, but keep in mind, what's happened is, we didn't have, I think we had one person from the housing authority that they generated, all right?
Not in South.
So all these people that we've picked up since the last time we've spoken are through Michael's efforts, not through the assistance of the town. We hope they pass muster. So we've gone out there and we've done it, but we cannot rely on, typically it's a very easy thing. The town gives you the people, you're there, you get a backlog, everyone's happy. This town has nothing, and they've tried. So if we have to bring the town folks here, we'll do so, but we're at wit's end, so we're trying, we have to craft a solution. You will see something that will be in the form of an amendment to try to craft a solution. We hope to get some feedback from you to see what we can do. We'll take some of your comments, we'll look at them, and try to incorporate them into a solution, but we do need help.
David, of all of the affordable units with apartments, 25% of them are affordable, they count 100% to the town's count.
Correct.
We change the permit, we go down to 20% and give you three back. What happens to the balance?
Exactly.
That's a problem.
That's a huge problem. So what you're saying is that we're going to lower the number of affordable so that they no longer count at 100% because of the state law. And so we lose that affordable count. And now it triggers any other developers saying, oh, they're not at their 10%, guess what?
And it could be that the market will control that you won't see any more 40Bs because there's no market.
It's not going to put you over the edge anyhow. You're really behind it.
What happens if you take somebody from out of town?
Yeah, you're at 4.1% of the 10% figure. affordable housing is not.
That's occupied, is that
Why can't
permitted
you-
40Bs? Or
That,
that's not permitted 40Bs?
Maybe not permitted,
Right.
it's what's all in the state level.
But that's what's already drawn building construction permits on,
Okay.
not permitted.
Yes.
Right.
That's what we believe.
What's the restriction on taking somebody from out of town?
There isn't.
There isn't any.
There isn't, really.
Why don't you do it?
We tried. I mean, I just have to
You
say.
mentioned Middleborough, that's why.
I have to say, it's not, believe me, this is, the people in here aren't all Middleborough by any means. It's not town restricted. It's,
I thought you said earlier it was.
no.
Since the housing authority doesn't give us any replenishment
Yeah.
supplies, so they, as Michael said, they conducted a lottery and they didn't get anyone.
This isn't our problem.
How do they get the entries into the lottery? Is that by advertising, or?
Yes. This whole process was done by the town Middleborough Housing Authority in conjunction with.
Maybe these issues should be addressed to the people that are supposed to come up with the tenants.
We've tried that. Unfortunately, they have directed us this route because they're not the governing jurisdiction that made the decision.
Well, I talked to Jane today, and she said they were working on it, and she's working with people, so, because I just gave her a heads up that you guys were coming here to, looking for an idea for a decrease, and she did say that she's been working on it. So-
We've been in constant contact with, it's Ruth, Joanne Ruthowitz, and we've been in constant contact with her, managing this situation. But still, to this day, right now, every single tenant has been occurred from us.
Right.
And
I think
typically,
she said out of the 18, you have 6 left, correct?
correct. That's what it shows on the sheet as well.
I guess my only question is, we really don't know the impact of lowering the rent by any dollar amount, what that might do. And I understand your position, and I would probably take the same approach first before I had to give up 1 year's worth of lower rent. But the fact of the matter is, we really don't know where the threshold of objection really lies. So it could be $75, it could be $100, it could be $150 or $200, like Joe said. And I just don't see that it's the responsibility of this board to figure that out.
We're not in the price point business here. There's no possible way of doing that. I mean,
All we can do is offer suggestions.
it's not that we don't want you to do well, and it's not that we don't want your project to be successful, but we represent the town. And it's in the town's interest to get as many of these affordable units counted as possible. And I would not do anything, at least from my perspective, that would alter that count in any way.
Okay, well, we appreciate your time. We'll consider it, we'll keep beating the sticks out there and see what we find.
Okay.
Thank you.
Thank you.
Thank you. Thank you.
Findings? Pardon?
The tower and the road.
We don't have findings on the tower. There's no storage, there's no water, there's no public utilities.
Is the site appropriate for
I
the
mean, we
use?
still need a finding on it.
Okay, all right. The AT&T wireless tower, changing of the antenna, the site.
You and me both.
Number 1 under the findings, the proposed site is appropriate for the use and the structure. Nothing else pertains to.
The water, there is no such thing as water.
Huh?
That's fine, just one's fine, Norman.
There's one finding, and that's it.
That's it.
Fine.
The the proposed site is appropriate for the use and the structure.
Motion made and seconded. Any discussion? All in favor?
Aye.
Opposed? So voted.
And then we have Teresa Hoy, 182 Cherry Street, in-law apartment. The proposed site is appropriate for the use. Number 2, public water is available and on-site storage has been approved for the use.
Second.
Number 3, the use involved will not be detrimental to the establishment or future character of the neighborhood and town, subject to appropriate conditions or safeguards if deemed necessary. Number 4, there will be no nuisance or serious hazard to vehicles or pedestrians. Number 5, adequate and appropriate facilities will be provided to ensure the proper operation of the use. Okay?
Motion, thank you. Motion made and seconded. Any discussion? All in favor?
Aye.
Opposed? So voted unanimously.
Adjourn at 9:45.
Second.
Now you're 3/4 of an hour beyond your nap time.
That's about it.